Hello and welcome back to Coin Lady channel. Threats to XRP markets. The actions of Ripple have sparked heated debate among prominent attorneys. Now, this is a continuation of a topic that I've already discussed on my channel. Just the day before yesterday, I was bringing attention to a Twitter exchange that included an attorney who had formerly worked for the SEC. In addition, after I had already shot the video, attorney John Deaton chimed in with his own thoughts and opinions, emphatically countering the ones I had presented. Most, if not all, of the suggestions made by the disgraced SEC lawyer. As a result, I feel compelled to tell you this. I have no idea how you feel about this, but I really enjoy reading this. Human beings are fascinating to me. As long as everyone is being logically consistent, it's a good time. Sure, anything. Screaming at each other can be amusing, I suppose. However, I much prefer to see intellectually honest opponents argue with each other. That's a blast, in my opinion, and that's exactly what we have here. And yes, I'm partial, but it seems to me that attorney John Deaton has the upper hand in this case on secondary market transactions. In contrast, if XRP and crypto in general. But before we go any further, I do want to clarify something. I come from no financial or legal background. You shouldn't buy or sell anything based on what I say or write because I am not a legal or financial advisor. I'm just a fan who occasionally posts videos to YouTube regarding crypto-related things for kicks. So, I won't bother going over the same ground I did in yesterday's video. And don't worry, you may still enjoy this video without having watched the previous one. What we're discussing now is quite different from what we talked about yesterday. So, while it does build on this, you shouldn't feel like you're missing out if you haven't seen that video. Yes, you are, and you really should tune in. I take offense if you don't enjoy that specially prepared room temperature jam. But don't worry if you haven't seen it yet. And you will. You'll be just fine. Keep going as you are. You can perform them in whatever sequence you like. You should watch the video to get the full effect of what attorney Deaton said when he intervened here with former SEC attorney Mark Farrell. By the way, they were discussing the concept of fair notice. And, to be honest, attorney Deaton agrees with you there. He has been rather public about his belief that all cryptocurrencies should pass the Howey test when they first launch, and he has declared as much. And I can certainly understand why his lawyer, Deaton, is taking that position. Simply put, there has always been a single point of failure in the architecture of any cryptocurrency I'm aware of. Some people made it possible. Bitcoin, too, had a centralized beginning. If there is a caveat to this that I'm missing, then that's okay. So if you find any extreme cases, please let me know. Even if that's the case, attorney Deaton's main point, that almost everything, if not everything, will pass the Howey test, stands. Okay, if we're talking about the very first moments of inception. Solicitor Deaton responded with the following. Some of what he wrote went like this. I've stated that initial sales of most altcoins violated Section 5. You're well aware that secondary sales have always been a problem for me. Because of this, I agreed with the judge that his ruling did not apply to secondary markets and thus became an amicus curiae in the library case. Because the library had already lost its books by the end of January, I'm sure you remember it was then. They suffered a loss. It was either the first week of November or the last week of October, thus early November of the previous year. The library failed. In my opinion, the verdict was not the best possible outcome. If you've been paying attention, you know my opinion on the matter. There was a hearing on the remedies aspect of this case in late January, and attorney Deaton was given amicus status. That's why he had the freedom to share his thoughts on the matter. The judge agreed with attorney Deaton that the judge in that instance was not ruling on secondary market sales. Then, Kashta, a member of the XRP community, replied to Deaton's legal inquiry with, unless I'm mistaken, Mark. So, once more, that's Mark Fagel, the ex-attorney for the SEC. Although Mark has claimed that the issue of secondary sales is not at issue in the Ripple SEC lawsuit, I believe that this is in fact the case. As a matter of fact, I believe the SEC stance is that every transaction is an investment contract. Is that how you see it, Mark? Yes, what you said about money is right. In fact, if I can locate the tweet, I will swiftly bring this to your attention. Former SEC attorney Mark Farrell made the following false assertion. Once crypto gains practical use beyond mere speculation, he speculated, secondary market trading could be governed by different standards. There is no court case involving such issue. Mark Farrell, an attorney who has worked for the SEC in the past, seems to be intellectually forthright, yet he is mistaken here. Based on my observations, I have a strong suspicion that he is telling the truth. Simply said, I think he's off base and wrong. He doesn't have all the information on the case. This is where attorney Deaton did a great job of explaining everything. XRP community member Cashton made a statement that was retweeted by attorney Deaton, and he has just laid it out in a way that absolutely destroys attorney Farrell's position on the matter. I absolutely adore what attorney Deaton has written here. I enjoy reasonable debate because, as I've already mentioned, it can be just as entertaining as an occasional shouting bout. Not my thing because I think the only real reasonable way to get to a place where you can believe as many true things as possible in life is to have people who are civil disagree with each other and just try to get towards that end and just figure stuff out. And that's exactly what's occurring, and that's why I'm having so much fun with this. So, here's what Deaton says in his legal capacity. Let me reiterate my letter to the Honourable Judge Torres, which is an exact quote from the brief filed by amicus attorney Deaton in the matter of SEC v. Ripple. For the SEC, every sale of XRP from anywhere in the world offered by anyone, including AMSI, was, is, always was, and always will be the offer and sale of a security. The SEC asked the court to validate its shorthand and analytically lazy contention that Ripple has engaged in the functional equivalent of a 9-year-long, ongoing 24/7 ICO. Since this was a legal document, I'll pause to point out that he also provides the citation in terms of where-like references to what is being referred. That section is skipped by me. You can view it right now if you want to. I figured I'd make a quick note of that, but otherwise I plan to ignore them and speed on. Next, the defendant emphasized, he wrote to the judge that, once again, a purchase of XRP represented an investment of money into a common venture with other XRP investors. When you buy XRP, you join other investors and Ripple in a joint venture. That investment contract is represented by XRP, which is exchanged even in the secondary market today. Again, these are direct quotes from documents written by the SEC that Deaton presented to Judge Torres. That is the precise position taken by the SEC. The SEC's XRP idea, according to attorney Deaton, is so outlandish that it captures all possible future sales, even in foreign locations. Then he added, in parentheses, quote, even if some country were to recognize XRP as fiat currency at some point in the future, that would result from defendants' significant entrepreneurial and managerial efforts to date and likely in the future, on which public investors expecting profit relied when making an investment in defendants' common enterprise. So that's the SEC's exact argument. They're contending that this whole notion is so outlandish that it traverses space and time into the future, as attorney Deaton puts it fairly accurately. The SEC, in fact, made that case. The SEC is definitely making this case, I can tell. The lawyers who drafted this cannot possibly think it is legal or even remotely acceptable. However, these jerks are talking about it now, so it must be true. That's what I want to say. That is not what I mean at all. The SEC's Howie claims, the attorney argues, have grown so broad that they cannot be contained in either space or time. As previously mentioned, the SEC is requesting that the court accept as true the assertion that Ripple introduced XRP to the globe based on private statements made by Ripple personnel to a small group of people several years ago. The SEC may not circumvent the Howey test by claiming that all past, present, and future sales of XRP satisfied all three Howey requirements without providing any further transactional proof. Also, that's been a major source of frustration for me. Please allow me a moment of your time to hold and make my observation, as I'm aware that Judge Torres may return and discover that Ripple. Did you maybe break the law when selling those stocks and bonds? The fact that the SEC didn't argue against any particular transactions is a large part of why it would upset me if it were to happen. They disclosed all information. Therefore, it's possible that Judge Torres will pick and choose which facts to consider. To be honest, I'm not sure she will. Perhaps she will. But it would really upset me since, as lawyer Deaton shows out here, every single XRP transaction that has ever happened or will ever happen till the end of the world is included in this. The credit for that success goes to Ripple and its team. The SEC's line of defense would be that this whole thing logically belongs within their purview. What a load of rubbish. I've always maintained that. Anyone who starts from scratch will know nothing about this and will have to educate themselves. In my opinion, nearly everyone on the planet will go completely nutty for Cocoa Puffs. Didn't Brad Garlinghouse say something to that effect? However, Attorney Deaton insists that each transaction be subjected to the Howey test and evaluated in light of the law as it existed at the time of the transaction. And by the way, he uses the case that established that precedent to back up his claim. The SEC, according to Attorney Deaton's statement, instead argues that the XRP traded even in the secondary market is the embodiment of those facts, circumstances, promises, and expectations. This day marks the beginning of that investment agreement, end quote. The lack of a single reference to a precedent or authority backing such a unique assertion is striking. Imagine. Even the SEC probably doesn't know what that sentence means legally. Exactly. Since I intend to refer to this again and again, no footnote is necessary. What does it mean? There is no source given. They use it as an example because it stands for everything XRP is supposed to stand for. Just what the devil are you thinking of? Whatever it is they do over there, it ain't law over here. I can assure you that everything they do at the SEC over there is not legal. The SEC's position is the same as asserting that each person is an independent entity, says Attorney Deaton. Pay attention, everyone. The notion put out by the SEC can be compared to debating apples and oranges. We're not just apples and oranges, we also both represented the W.J. Investment Agreement. Company Howey. If innocent holders weren't being gravely damaged by the SEC's idea, it could be funny. That's what he told his lawyer, not what his lawyer told Judge Torres. That is why it is so eloquently stated. They oranges. I apologize. The oranges stand for those assurances. The actual oranges. I apologize. Imagine if that debate had taken place in 1946. It's evidence that no similar argument has ever been made. Attorney Dean then mentions fellow ex-SEC attorneys Mark Farrell and John Reed Stark. Who? John Reed Stark, in my experience, is not always intellectually honest, but based on my interactions with Attorney Farrell, I believe he always tells the truth. Simply put, I disagree with him. But John Reed Stark, I can't stand reading any more of what he writes. How he could possibly think that is beyond me. Perhaps he does, and if so, he might be mistaken. To be honest, I'm having a hard time believing it right now. Or it's just not plausible to me. In any case, by all means, attorney, label them as such, and go ahead and tell Mark and John and anyone else who is competent and knowledgeable. Ex-SEC enforcers can make a strong case that Ripple broke the Securities Act Section 5 at some point. They have a good case for claiming that most cryptocurrencies are hoax and that securities rules are broken. They can't make a convincing case that the SEC's approach in the Ripple case, as evidenced by the SEC's own briefs, is legal or safeguards investors. Because of this ridiculously broad theory, I've said the SEC grabbed defeat from the teeth of triumph. In the 76 years after Howey, no court has determined that the asset underlying an investment contract is always a security. Not real estate, a barrel of whiskey, some chinchillas, the cryptocurrency Bitcoin, and source code. There is no evidence of any investment contract between the buyer and the promoter in the ensuing 76 years, Howey. The SEC's lawyers should be embarrassed by their client's ludicrous argument. The judge criticized them for being hypocrites and lawbreakers. Not I, but Judge Netburn, said that. If I were to say it, I probably wouldn't be as diplomatic. That's so cool. That's an excellent conclusion to his argument. This definitely shattered the defense attorney's credibility totally. The SEC is not disputing the existence of secondary market transactions, as you may have heard. Without a doubt, they are. True enough. It's refreshing to see an argument demolished in such a respectful manner. Attorney John Dean did a fantastic job. There was a tag for attorneys, but I don't know if Mark or John will answer. If they do, it's something I'll have to address in a future video. However, for the time being, this is the final chapter. And yet, I find great pleasure in this material. Even if you don't agree with the arguments being made, you should find it entertaining to listen to the attorneys argue with each other. Nonetheless, if there are any new developments, I fully intend to report on them. If the story continued after this, it would be the end of the thread. But I think I should end this now. Contrary to popular belief, I'm not a professional banker. Nothing I say or write should be used as a basis for making financial decisions. Please like and subscribe my channel. See you later, bye.